Vice Chair, can you hear me? Great. Good morning. We're on the record in case number 2021-00365, electronic application of Kenergy Corp. For a certificate of public convenience and necessity for the construction of a high-speed fiber network and for approval of the leasing of the network's excess capacity to an affiliate to be engaged in the provision of broadband service to unserved and underserved households and businesses in the Commonwealth. My name is Kent Chandler. I'm chairman of the Kentucky Public Service Commission, and I will be presiding over the hearing today. Joining me today via video conferencing are Vice Chairman Amy Cubbage and Commissioner Mary Ann Butler. To help with clarity and avoid feedback issues during this virtual hearing, please do the following. Set your cellular phones to silent mode or turn them off. Please mute your computer microphone if you are not speaking. Attorneys, when interjecting, please state your name so that the video record is clear. If you use a phone for audio and a computer for video, please turn off the computer audio, otherwise there will be feedback. If you are in a room with several people on their own computers, turn off the computer audio for all but one computer, otherwise there will be feedback. If another participant is in a nearby office, please close the doors between offices. Use wired headphones or wired earbuds for better sound quality. Please keep a charger nearby in case your battery runs low. And finally, please alert staff if you're experiencing technology failure that prevents your participation at any time in the proceedings. Attorneys should contact staff at the previously provided contact information. The hearing today is for the purpose of taking testimony in support of Kentucky Broadband and Cable Association's motion to intervene, including testimony on Kbca's special interest that is not otherwise adequately represented, or the issues and facts that Kbca will present that will assist the Commission in fully considering this matter. At this time, we'll have the entry of appearance of counsel. Given the unique challenges of doing this via video hearing, I also request that each party's counsel identify their witnesses at this time. For the Kentucky Broadband and Cable Association.
Good morning, Mr. Chairman. My name is Todd Osterloh. Along with me, Jim Gardner, with the law firm of Sturgill, Turner, Barker, Maloney in Lexington, Kentucky. We are representing Kentucky Broadband and Cable Association. Along with us today, we have our primary witness, Jason Keller. We have also identified Michael Chwanek as a potential witness. At this point in time, we don't anticipate calling him, and that's who we are. Thank you.
Thank you. And for Kenergy Corporation.
Morning, my name is Chris Hopgood. I'm counsel for Kenergy, and with me is Jeff Hone, the CEO of Kenergy. I don't anticipate calling him as a witness, but he's here in case.
Okay. And Mr. Hopgood, you identified two other witnesses. Did you intend on calling them today?
I do not.
Okay. Now, the Attorney General is a party to this case, but I don't see that they've decided to participate in the hearing today. So we'll just make sure the record reflects that. And for staff.
Nancy Vinsel for Commission staff.
Thank you, Ms. Vinsel. All right, Mr. Osterloh, as the party with the burden of proof that satisfies the standards in 807 KR 5001, I'll allow Kbca to introduce the evidence and experts that they would, or the witnesses that they would like first. What we'll do is, I guess we'll follow the ordinary process whereby you'll tender your witness, or you'll introduce your witness, we'll put them under oath. You'll be able to conduct direct examination in support of your petition for intervention. Then you'll tender the witness for availability for cross-examination by the applicant, by staff counsel, and then by the commissioners, and then give you an opportunity to conduct redirect.
Thank you, Mr. Chairman. Our first witness is Jason Keller.
Mr. Keller, please turn on your camera, turn on your microphone, and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Jason Keller, 1560 Tates Creek Road, Lexington, Kentucky, 40502.
Okay. Mr. Osterloh, you may ask.
Thank you, Mr. Chairman. Mr. Keller, you work for Charter Communications, correct?
Yes,
And what is your current position with Charter?
I'm the Vice President of Government Affairs and Regulatory Strategy.
How long have you been employed in that position?
Almost 2 years.
And before that, what was your position?
I was the Senior Director of Government Affairs, led state and local government issues for Kentucky and Tennessee for Charter Communications.
How are you also affiliated with the Kentucky Broadband and Cable Association?
I've served as board chairman since 2012.
What is KBCA's business address?
1617 Foxhaven Drive in Richmond, Kentucky.
And can you tell the commission a little bit about what KBCA is?
Sure, it's the organization, it's the trade association that represents Kentucky's investor-owned cable companies.
Can you generally describe KBCA's member entities?
Yeah, the member companies operate in nearly all 120 counties across the Commonwealth. They offer high-speed broadband service, cable television, landline telephone. Several operators also offer mobile services to nearly 2 million Kentucky homes and businesses.
And how many customers do KBCA members provide broadband service to?
So KBCA members, as I mentioned, have invested in networks that extend service to and other connectivity services to nearly 2 million homes and businesses. But of those, more than 1 million Kentuckians receive broadband service from a KBCA member company.
Okay. And how long have you been interacting with the Kentucky Legislature on broadband and cable issues?
For 9 years.
Has that been in your capacity with KBCA?
Yes, I've been a registered legislative agent for Charter Communications and prior to that, Time Warner Cable.
And am I correct that Charter is a member of the association?
Yes, that's correct.
Okay. What is your understanding of Kenergy's request in this case?
So Kenergy, as my understanding is that they're requesting commission approval to do 3 things. One is to construct a high-speed fiber optic cable network, 2, to lease excess capacity on that network to an affiliate of Kenergy, and 3, further noting that their affiliate would lease capacity to a sublessee.
Okay. And is it your understanding that the General Assembly recently authorized rural electric co-ops to provide broadband service?
Yes, during the 2021 legislative session.
Okay, and that was House Bill 320, correct?
That's correct. The General Assembly enacted House Bill 320, which allows a distribution cooperative to facilitate operation of an affiliate that's engaged exclusively in the provision of service to unserved and underserved areas of the state.
Has the association and its members been involved in policy discussions related to deployment of broadband to underserved and unserved areas in the Commonwealth?
Yes, certainly. We've been deeply involved in addressing the issues of rural Kentucky and have been highly focused on deploying broadband to underserved areas. And from a policy perspective, we've worked with a number of entities, including the Kentucky Association of Electric Cooperatives, most recently to help enact the Broadband Deployment Fund, which was just established during the 2020 legislative session and funded during the 2021 legislative session.
And maybe, can you provide the commission with your background in those policy discussions related to House Bill 320?
Yeah, so House Bill 320, which passed last session, is as with many broadband issues that arise before the General Assembly, members of leadership and relevant committee chairmen in both chambers of the General Assembly reached out proactively and asked my company and our association if we had a perspective on the legislation. And I affirmed that my company and our association were not opposed to that legislation because we felt like it struck an important balance, an important policy balance that would enable electric cooperatives to facilitate a broadband affiliate, but only do so in areas that are designated as unserved or underserved. And that was defined in the legislation as those locations that lack access to 10 by 1 megabits and 25 by 3 megabits broadband service, respectively.
And when you refer to 10 by 1 or 25 by 3, that's download and upload speeds, is that correct?
That's correct. So the 10 megabits download by 1 megabit upload speed was defined in Kentucky legislation as unserved, and underserved was 25 megabits download by 3 megabits upload as underserved locations.
Did legislative leaders during this last session in their public comments further affirm your understanding of the bill?
They did, both privately and publicly. And in fact, State Representative Brandon Reed, who co-sponsored the legislation and presented it on the floor of the House of Representatives, stated that the House Bill 320 would, quote, clear the way for rural electric cooperatives to feasibly provide broadband service in unserved and underserved households and businesses through an affiliate. And it's because of the General Assembly's clear language and their intent represented in that legislation that electric cooperatives should be allowed to provide services through an affiliate that was exclusively deploying service in those areas. We believe that the legislation served to advance the Commonwealth's goal that broadband would be accessible to every Kentuckian.
Great. So I guess with that in mind, why does the association seek to intervene in this particular case?
So the association would like to provide information and develop issues that would assist the commission in rendering a decision, part of which would be based on ensuring the letter and intent of the law, that the electric cooperatives would facilitate an affiliate engaged exclusively in the provision of service in unserved and underserved areas.
But let's maybe elaborate on that a little bit. You mentioned providing information to the commission that will assist them in considering the matter. What kind of information can the association provide to the commission?
We have an extensive amount of information that would help determine which areas are unserved or underserved, including maps denoting the current and planned footprint of broadband networks today.
And so would that type of information be available from another source?
No, there's currently no reliable map that details where broadband is and is not available across the Commonwealth. And in fact, published maps like the Federal Communications Commission's Form 477 data can be both over and under inclusive of where broadband service is located. In fact, the published broadband availability data can be over inclusive because they frequently overstate the availability of broadband service in rural areas, because they identify census blocks at the census block level, and if one home has broadband service in that census block, the entire census block is designated as served. So it overstates, it's over-inclusive from that perspective, but it can also be under-inclusive. So my company, for instance, in 2020 alone, we extended service to an additional 24,000 homes and businesses across Kentucky. And those are often not represented in the FCC or other entities' maps because deployment is happening in a very rapid pace across the Commonwealth, and the maps that are in place today would not account for that.
Okay. And am I correct that state government is establishing some sort of protocols to resolve questions as to whether broadband service is available in certain areas in the Commonwealth?
So in the legislation I mentioned earlier that established the State Broadband Deployment Fund, which is administered by the Kentucky Infrastructure Authority, the state instituted a challenge or a verification process to ensure funds were not invested in areas where broadband networks have already been constructed. And in fact, that challenge process for the first $50 million of funds allocated to it is currently ongoing now and will close in early December. And it's because of the way that the legislation, House Bill 320, was constructed last session. We believe a similar dynamic is in play in this proceeding.
So there again, in this proceeding, what type of information does the association have that could benefit the commission?
We have detailed maps denoting the current and planned footprint of broadband networks, including areas where broadband is already scheduled to be expanded through the broadband grant programs at the federal and state level.
Okay. And so can you describe some of the issues that the association is interested in developing in this case?
So we currently provide, our association, our member companies currently provide high-speed broadband service, as mentioned, exceeding the definition of unserved and underserved areas in portions of Kenergy's footprint that overlap with Kenergy's facilities. And as a result of that, the association has important insight into where areas are eligible for broadband deployment by electric cooperatives and their affiliates.
Okay, and in our motion, we also mentioned the statute, I think it's KRS 78.2201, and it prohibits a regulated utility from subsidizing non-regulated activity. Can you elaborate a little bit on why that's an important issue of interest to the association?
Certainly, our association has an interest in ensuring a fair, level playing field across the state. And if Kenergy's electric ratepayers are subsidizing its broadband offerings in an area where broadband is currently available, we believe the playing field is not level in that case.
Okay, and as we are well aware, one of the prongs for the commission to grant intervention has a clause in there that the intervening party would not unduly complicate or disrupt a proceeding. Does the association intend to do that?
No, in fact, quite the opposite. Our goal is to keep our engagement as limited as possible on the issues that I've outlined here today.
And to that end, we've timely submitted our filings, including a relatively short set of data requests, correct?
Yes, that's correct.
And maybe one last point before I turn you over for cross-examination. In response to our motion, Kenergy suggested that the association is merely a competitor to Kenergy. Is that accurate?
No, in fact, it's a bit confusing to us that Kenergy would consider our association members a competitor. We firmly believe that a number of entities, including electric cooperatives, can be part of the solution in helping provide better broadband to unserved and underserved Kentuckians. But the legislative language and intent of House Bill 320 was very clear. Where broadband service is defined as a lack of access to 25 megabits, 25 by 3 megabits is not available, an electric cooperative has the ability to facilitate an affiliate and provide those services. However, where there is service available today, they do not. So as a result of that, we were a bit puzzled by their concerns about the competitive implications of our involvement in this proceeding.
Thank you, Mr. Keller. Mr. Chairman, this witness is available for cross-examination.
Let me ask one question before we turn it over to Mr. Hopgood to see if he has any questions. Mr. Keller, I'm confused about your last point. Are you saying that Kbca members don't intend on extending service to unserved and underserved areas?
In certain respects or in certain circumstances, I think we certainly would, Mr. Chairman. I don't know what those specific plans are of certain association members, but I think in certain cases we would be doing that, yes.
Okay. So I'm kind of confused by your response there. You're not saying that Kbca members intend on only serving the customers they currently serve, that you have an expectation that, let's just take Charter, for instance, you have firsthand knowledge, that you all do intend on extending service into unserved and underserved areas. Is that correct?
Absolutely, Mr. Chairman, and I would make two points on that. Is one, my company participated quite heavily in the FCC's Rural Digital Opportunity Fund, the RDOF, in which we were fortunate to be the recipients of more than $100 million in federal funds through that program. $58 million in funds through that program. We actually invested $100 million of our own money to extend service to more than 31,000 households across the state. So we were participating heavily in that. And then also in the State Broadband Deployment Fund that is currently ongoing now, we actually just put grant applications in for that to serve unserved areas of the Commonwealth that would total another $155 million worth of projects across the state. So, and that's just our company. That's just one company out of the more than dozen that are members of the association. So we are certainly focused on expanding broadband to areas that do not have it, and we will be doing that, we think, at a very significant pace.
Okay. Mr. Hopgood, do you have any questions?
Just a few, Mr. Chairman. Mr. Keller, your group does not include any entity that provides electric service, does it?
Not to my knowledge, we do not.
And your group doesn't profess to have any expertise in the providing of electric service.
We don't provide electric service today. We provide connectivity services.
And your group wouldn't be helpful in advising the commission on anything to do with electric service then?
I think I've outlined where we think we would be a value add in this proceeding, and that is in the context of providing information related to maps and that type of information concerning where broadband service is available today.
And you identified that the chief regulated issue in this case is whether Kenergy can build a smart grid network for its electric needs. You're aware of that?
I believe there were other elements of the proposal as well, including the leasing of the fiber to an affiliate and the subleasing to a additional entity as well.
And those are unregulated, but you would agree that this one, the regulated issue is the construction need for a smart grid network. That's the Kbca part of this. Do you agree with that?
I would not have knowledge about the specifics of that. I know that the legislation, it sort of included all of those elements related to the provision of broadband service as well.
And providing broadband is an unregulated aspect in this Commonwealth, correct?
Yes.
Your group's sole interaction with electric utilities is regarding pole attachments and pole attachment rates. Is that correct?
I believe we provide service, broadband service to a number of electric cooperatives as well. And we've been in discussions with a number of others to do that as we're expanding service into other areas of the Commonwealth.
But on a statewide basis, your group, the Kbca, their interaction with the Kentucky Association of Electric Co-ops, as you mentioned, was in working on pole attachments, and then the next step is pole attachment rates. Is that correct?
We also work very closely with them, actually hand in hand with them, on the development of the Broadband Deployment Fund, which was the fund that has been that the General Assembly allocated $250 million to. To expand service to unserved and underserved areas of the Commonwealth. The Association of Electric Cooperatives was highly involved in that legislation as well.
And the other thing you mentioned earlier was that you all worked hand in hand with Kbca on the current regulation that's about to be submitted on pole attachments. Is that correct?
I'm not sure if we worked hand in hand with them on it. I know we were certainly part of the regulatory process, as was the association that appeared before the commission and also filed on behalf of the commission. I don't know if we could characterize it as working hand in hand with them on those regulations, though.
Let me rephrase that. You were a part of the group with Kbca that was working on the pole attachment regulation that was referenced in House Bill 320. Is that correct?
We participated in the commission's process of that.
Correct.
Yeah.
Right. And that there is, you all have, or I believe someone's introduced legislation about a pole replacement fund in the upcoming legislation, in the upcoming session.
Mr. Chairman, I just want to object. I feel like we're getting far afield when we're talking about pole attachments and things like that to what's actually at issue in this particular case, which is deployment of broadband in unserved and underserved areas, along with the CPCN.
I don't know that it's any less related to the underlying application than KBCA's involvement in the the broadband fund that sits at KIA. So I would agree, Mr. Hopgood, to sort of make sure we're pointing in the right direction. So
I'll move on.
Continue. Yeah.
We'll move on, Mr. Chairman. Mr. Keller, is it your position that the PSC staff then cannot adequately address a CPCN of a regulated entity?
No, our perspective is that we have additional information that would be informative to the process, including maps that, as I mentioned earlier, are not currently available today, and that we would be helpful in that context.
Well, would it be adequate then for you all to simply file your maps and then you wouldn't need to intervene?
Well, we're actually encouraged as part of the request that Kenergy made last year to the commission. It was referenced in that response that the appropriate forum for us to be engaged in this discussion would actually be when Kenergy would file for a CPCN. So we're simply doing that at this time. That was something that was mentioned last year, and so we think this was an appropriate forum for us to be engaged.
Mr. Chairman, those are all the questions I have this time.
Ms. Vincel?
Yes, thank you, Chairman. Good morning, Mr. Keller.
Good morning.
I'm going to ask you some general questions before I delve into some more specifics. And I'm sure that your attorneys have thoroughly prepared you. I wanted to make sure that we have on the record what the standards are for intervention. Again, I need to be clear. I know that you are not an attorney, and I'm not going to ask you for any legal opinions here. But for permissive intervention, there's a two-prong standard, and this is an OR standard, that a party who wants to intervene has to have a special interest that is not otherwise adequately represented, or that the entity can develop issues, present facts that will assist the commission in reaching its decision. Also, one of the key provisions of everything that we do at the commission is that while we have plenary authority, our jurisdiction is limited to the rates and service of a regulated utility. So I wanted to make sure that was just out there for this hearing. I need to clarify one piece, and I'm hoping that you're going to be able to do that for me. Is Kbca requesting to intervene regarding the scope of the CPCN request made by Kenergy, or is there any issue arising from the leasing of excess capacity to connect the non-jurisdictional utility? And if you need me to rephrase that, because that was a bit of a compound.
No, I think I tracked with it, and but I think the issue arises in the provision of service to the end user. So that would function through the leasing of the network to an affiliate.
So I just want again, I want to make sure that I'm clear. The request to intervene is not so much the scope of the CPCN, but instead addresses the leasing of the excess capacity? As you
Yes,
understand.
I believe that would be the case, yes.
And is Kbca representing itself in this case, or a particular member?
It's representing itself. I'm appearing here. I work for Charter Communications. I'm appearing as the board chairman, but also Charter Communications is the largest member of the association. We represent more than 80% of the customers that make up cable operator subscribers across the Commonwealth. So the other operators that are members of the association often rely on us for our for us to participate in these types of issues.
I want to make sure I understand what you just said. So of the membership of Kbca, looking across all of the members, Charter serves about 80% of the customers served by Kbca members?
Yes, ma'am. That's correct.
You mentioned that KBCA's headquarters are in Richmond, Kentucky, so that, my question is whether KBCA would be a customer of Kenergy, and I think that answer is clearly no, correct?
That's correct.
Are there any KBCA members that are customers of Kenergy?
I know that our service footprint overlaps, Charter Communication Service footprint overlaps in a portion of the Kenergy service footprint. And I know that there are other cable operators that also overlap with the Kenergy service territory. I don't know whether or not they are customers specifically, or frankly, I don't know whether we are a customer either, although I would assume that we would be if we have a facility at some location.
And in regards to the decision to request to intervene, did the KBCA board make that decision? Let me put it this way. Was there a formal vote by the KBCA board to intervene in this case?
There was not a formal vote. We discussed the issue at our recent board meeting that was held last month. We were, the board wanted to engage in this issue, and that's why the intervention was put forward. I don't recall if we had a formal vote on the issue, though.
But the board, you said the board discussed this last month, in October?
Yes, ma'am.
Okay.
We had a board meeting in October. It was in late October. I don't recall the exact date.
Okay. And would the board meeting have been after the motion to intervene was filed?
I don't recall. I'd be happy to get those dates. I don't recall when the motion specifically was filed and when our board meeting was, but we could certainly.
Well, I'm sorry, I didn't mean to talk over you. My underlying question is, who made the decision for KBCA to intervene, to file a motion to intervene?
So the association collectively did.
But I don't want to make sure I make too much of this, but I want to be clear. If the board didn't vote on this, so there was no formal vote, and if the discussion looks like it was made right around the time, perhaps after the decision, the motion to intervene was filed. So my question is, was this decision made by a single or a couple people rather than, by the board? The association is what we discussed this at the board meeting. I don't recall what the timing was specifically of it. Certainly, the primary members of the association, ourselves, and also Comcast, are engaged in all of these issues on a day-to-day basis. Many of our members are not. In fact, most of them are not. Many of them are very small members that have very small systems in Kentucky. So they often rely on Charter and Comcast to work through these issues and to make recommendations. But I don't remember the specifics of the timing related to that decision. You earlier testified about the maps, that KBCA would be able to provide maps, and that would be part of the information that was presented. Did I understand correctly that you just said that the maps you're referring to are not currently available?
They would not be publicly available. Generally speaking, the maps are proprietary information, proprietary and confidential to those broadband companies. So they would not be publicly accessible at this point in time, which is why we would be able to provide additional information that we think would be informative.
As I said earlier, the commission's jurisdiction is limited to rates and service. So thinking of that, I want to walk through some of the assertions about, first I'm going to start with Kbca special interest. In the motion to intervene, Kbca said that its special interest was as a provider of services to ensure that there is a level playing field. Again, I'm not looking for a legal opinion, I'm looking for a lay opinion. How does ensuring that there's a level playing field relate to this case in particular, but the commission's jurisdiction over rates and service?
Your Honor, or Mr. Chairman, can I interject? Because I really do feel like that is, I mean, that's essentially a legal argument that we're positioning ourselves in this case, less so for a fact witness. And so, I mean, I think we're happy to articulate that, but I'm not sure that this witness is the best person to answer that.
Well, I guess the question is, Mr. Oslo, if we're trying to act, it's not just a legal determination, it's a factual determination whether somebody has a special interest. And insofar as Ms. Vincel's attempting to determine whether there's factual support for the assertion, I don't find it, not relevant. And so I'm just curious if you could elaborate on your objection.
Yeah, absolutely, and I appreciate the opportunity to do that. As you characterized it, we're looking at a special interest, and maybe I interpreted Ms. Vincel's question differently. To the extent that we have a special interest, and we think we do, certainly the facts that underline that special interest, Mr. Keller is well qualified to testify on as a fact witness. Beyond that, though, the question, I believe, was premised on this idea that the commission has jurisdiction over rates and service, which is unquestionable. In fact, KRS 278.040 says that the commission shall have exclusive jurisdiction over rates and service. We don't think that the two things are tied as between, can we only look at the rates and service as to provide subject matter jurisdiction in this case. It's our position that once the commission has subject matter jurisdiction, which it does over the CPCN, then you set that aside, and that is not dispositive of who intervenes, because an intervener may not just be a customer of the applicant utility, but it would be one that has a special interest, as you indicated, that's not otherwise adequately represented, or the second prong, as Ms. Vincel appropriately recognized early on, that the potential party would be able to present facts and issues that help the commission consider the case. So just on that, to your point, Mr. Chandler, I believe that Mr. Keller is available to answer the question, what is the association's special interest in this case?
What I take Ms. Vincel's question to be is, what's the special interest in the rates and service? And you're saying that the rates and service have no bearing on what evidence or consideration or decisions or determinations the commission makes in these cases?
No. Once rates and service is an issue in the case and the commission has jurisdiction, then it turns to, does a potential party have meet one of those two criteria? And that special interest could go on. So what we have articulated is a special interest related to deployment of broadband in unserved and underserved areas. And that directly relates to KRS 278.5464, which is effectively House Bill 320 from this most recent session. And in fact, Kenergy even acknowledges that that's an issue in this case. In paragraph 38 of their application, Kenergy respectfully requests, and this is a quote, that the commission consider Kenergy's plans to lease excess capacity from construction of the fiber optic network to assist in the proliferation of broadband service in Kenergy's certified territory, vast portions of which are presently defined as unserved or underserved households by the FCC, when determining the proposed construction of a fiber optic network results in wasteful duplication. So that's where we see that delineation.
Ms. Vinsel? Your position?
My position is that Mr. Keller himself offered testimony this morning regarding the need to ensure that there's a level playing field. I think that Mr. Osterloh has addressed the legal side of it. I need to understand a little more from Mr. Keller what that base is how that ties to the special interest.
Yeah. I sustain the objection.
So let me go back and let me have you just start with explaining again, ensuring that there's a level playing field. Can you expand upon that as a special interest?
So I certainly from a level playing field perspective, our position is that if a regulated entity like a electric utility has the ability to utilize their ratepayer base to build a network that would effectively compete with networks that were funded primarily by private capital, then that creates a potential imbalance in the competitive framework of that area. That's just simply at the underlying basis for our how we think about maintaining a competitive playing field.
I'm thinking here about trying to figure out where to go next with that. I think you've answered what I've wanted to understand. You're speaking about the competitive framework, and I don't want to put words in your mouth, but is it that Kbca has concerns that Kenergy's ratepayers are going to be subsidizing a service provided within Kenergy's service territory that is not subject to commission regulation? Is that what you're saying, Mr. Keller?
I believe that's part of it, and then further being able to lease that network in areas where the legislation has specifically stated that it should not be, and those are in areas that already have access to certain levels of broadband services defined in the statute.
And I do want to explore that a little more about the unserved, underserved. Is it your testimony that the FCC maps that indicate broadband service are not reliable?
That's correct. As mentioned previously, the FCC the maps have often either overstate or understate the availability of broadband in certain areas. Most often they overstate the availability of broadband because they rely on a census block level basis. And that, so if one home or business within a census block it has broadband access, then all of that census block is deemed to have broadband access. And so that often overstates the availability of service. And in some cases, it understates the availability of service because we are continually and aggressively expanding service into unserved areas. Just my company alone last year expanded service to 24,000 homes and businesses that didn't previously have access to it. And we expect to do even many multiples of that moving forward as part of the Rural Digital Opportunity Fund and other funding sources that have been made available.
Would you agree that there's a logical inference that could be drawn in a census block if broadband is available to one household in that census block, that it could also be available to other residences, business, what have you, within that census block.
I think there's the potential for that, yes. Unfortunately, in rural areas, we often see that the availability of service is overstated in rural areas because of that issue. And quite frankly, that's as part of the broadband deployment fund, it sought to address that so that there would be a recognition that service could be expanded into census blocks that were already deemed to be served through the Form 477 maps, but would be able to address those homes that actually do not have service in those areas. So trying to take a more strategic, focused look at who actually has broadband service and who doesn't. And that's part of what that legislation sought to accomplish. But yes, in many cases, that if one home has service, then perhaps others within that census block do as well, but that may not always be the case.
And that's because the infrastructure may not have been laid. It may have been available to one particular home within the census block, but the infrastructure is not available to all entities in that census block. Is that a fair assessment?
Yes, ma'am. That's absolutely correct. Yes.
Okay. And again, this question is to clarify that when you spoke earlier and in the motion, Kbca said they also had a special interest in ensuring that the law is complied with. I believe what you're thinking of is the requirement regarding underserved and unserved areas. Is that correct when you speak of compliance with the law?
Yes, ma'am. That's specifically what we were referring to. Yes.
And you've spoken today about overlapping. Kbca members serve areas that overlap with Kenergy's. What's the basis for that claim?
We have pole attachment agreements with Kenergy. So their facilities, their poles and other facilities, we have agreements to be on their poles. We file permits and the like to provide service within their footprint. So we know where, generally speaking, their electric service footprint, distribution service footprint is, and where that overlaps with us because of our attachment to their poles.
And the maps that you could that Kbca could provide, is that the evidence that you would provide for the overlapping area?
Yes, I think that would be the primary evidence. Yes.
The other bit of this is it's not just that service is available in the area, but it has to meet the statutory download, upload numbers. So what evidence can you provide that documents that in fact these areas are not underserved or are not underserved because the download, upload speeds are met?
We can provide a number of different pieces of data from our marketing data to other speed test type of results that we conduct, and we do that in conjunction with our filings that we make to the FCC for the Form 477 data. We have a number of different pieces of data that we would be able to provide to affirm that our member companies provide services that meet and exceed the thresholds established in the statute.
And I want to make clear, I'm not casting any aspersions on anyone's marketing materials, but I know what my broadband provider's marketing materials say, and I know what my download and upload speeds are. They don't necessarily match up. Are there third-party speed tests that can also be provided or obtained?
There are, and that's actually what we provide as part of our filings that we make at the Federal Communications Commission. And so those are what are called SAM-NOS filings, and that's a third-party entity that conducts the speed that conducts those speed tests. And does so at the household level, at the tap level, and it reports that back. So that's what the FCC reports, and that's what we also have access to that as well.
And just to be clear, that the third-party speed tests, the third party, is that, is there a contract between a broadband provider and that third party, or is the third party a neutral entity completely?
I know in the context of the FCC filings, that's a third party that does that. I don't know what contractual relationship we have with other speed test entities and that type of thing. We could certainly find that information and would always be amenable to having third parties gauge our speeds, which we're certainly proud of.
And I recognize that the special interest and then the issues and facts presented overlap in a great deal, but I also want to make sure we touch on the issues and facts that Kbca says that it could present or develop. We've already touched on the compliance with the law, and again, I believe it is your testimony that compliance with the Kentucky law is really looking at the upload, unserved, underserved service areas based upon upload-download speeds. So I really want to look at the next item, industry-specific specialization, that there are issues or facts related to industry-specific specialization. Can you expand on that for me, what you're speaking of there?
I'm sorry, the term was industry-specific specialization?
Yes, I think what's really meant there is industry-specific information, facts or issues that could be developed that would assist the commission.
I'm sorry, was this included in our filing? I'm sorry, I'm not.
Well, is there industry-specific information that Kbca could provide to the commission that would assist us in reaching our decision?
I think what is likely referred to there are the maps and data related to them. That is the information that would be industry specific to our members that we would be able to provide to the commission. I believe that's likely what we're referring to there.
Okay. Chairman, I have nothing further for this witness.
Vice Chair.
Yeah, I have a few questions. Good morning, Mr. Keller. Are there any Kbca members currently providing broadband in Kenergy's service area?
Yes, I know my company does over a portion of it, and I believe that there are others as well.
Who are they? Do you know?
I don't know off the top of my head. I believe Mediacom is one of them, but we would happy to get a complete list for you.
Okay. In discussing the wasteful duplication language of House Bill 320, you were talking about the FCC maps and saying that because they're done by census blocks, which are fairly small, those could be over or under inclusive. You state that you have some, special knowledge of House Bill 320. How granular are we required to go? Are we required to go on a house-by-house basis to determine where broadband is currently offered and the speeds in our analysis under House Bill 320?
Well, I know that the definitions that were outlined by unserved and underserved reference the term location. That from our perspective, I think we are looking at a very sort of granular home and business level type of of data that we would be able to provide to define where service is and where it is not located.
But that's not specifically my question. The question was, are we required to look at it on that specific a basis, in your view?
I think that was at some level the intent of it. It was to look at it at as granular of a level as possible.
Okay. The maps that we've discussed quite a bit, what parts of the information that you have discussed could be submitted to us simply as a public comment that wouldn't be subject to any kind of confidentiality?
So our maps would need to be submitted under as confidential and proprietary. So that would be something that we would need to have assurances of to be able to provide that.
Okay. The FCC speed data that we discussed, is that public? Is that something that we could obtain from the FCC?
The Form 477 data is publicly available, yes.
At one point you said that your association's special interest is in making sure the law is complied with, the law being House Bill 320, which obviously every citizen has an interest in making sure the law is complied with. How is your association's interest distinct from that of a regular citizen?
We, as a broadband provider, we have invested significantly in broadband networks across the Commonwealth and are continuing to do so. So this is certainly something that we're able to provide information related to that where we have expanded our networks and where we currently provide service today.
Okay. With regard to the question of the prohibition against subsidy of a non-regulated activity in KRS 278-2201, I believe that came up in your direct testimony. Do you have any specific information to provide on that topic?
I'm sorry, Madam Vice Chair, which piece of that?
That was way too lawyer of a question. Let me back it up. There was some discussion of the fact that a regulated utility can't use the electric side to subsidize here providing broadband improperly. And I think that came up or was touched on briefly in your direct testimony. Does the Kbca have any information to provide regarding any allegations that Kenergy's proposal is unfairly subsidizing in this case?
I don't believe we have anything specific to that. I think our main goal is certainly ensuring that there is a level playing field related to the ratepayer subsidization of broadband networks, but further that where those are being leased to an affiliate or in subleased further from there, that they would be done so in only those areas as outlined by the legislation. So that, I think that was the main focus of our comments.
Okay, I think that's it. Thank you, Chairman.
Commissioner Butler, any questions?
No, not at this time. Thank you.
Mr. Keller, I have a few. So I want to be clear. Earlier you discussed a reply or response in relation to Kenergy's waiver request, that you were directed that was the inappropriate case to raise the issues that you raised, and that you were directed to raise it in a subsequent, CPCN or whatever proceeding you mentioned. Can you provide a little clarification on what it was you were discussing then?
Todd, I'm not sure if you have that information. I don't have the document in front of me at this point.
Yeah, Mr. Chairman, can I elaborate on that and then you can follow up with the witness?
I don't know about elaborate. I don't want you to testify, Mr. Osterloh. If you could at least identify the document that you're referring to.
Yeah, absolutely.
There's a lot of pronouns.
So,
yeah.
In a prior case, it's case number 2020-215. it was Kenergy's case, and our association provided public comment in that case. And this is detailed in our reply brief on the motion to intervene in section 3, starting on page 6. And after we filed those public comments on behalf of the association, in the post-hearing brief, Kenergy criticized the association for simply providing public comment as opposed to intervening. And Kenergy criticized the association for not being a part of the process effectively. They said that, or they suggested that the only reason that the association provided public comments was to avoid cross-examination.
Yeah,
And so that's
Mr. Osterloh,
what we do.
I'll sort of cut you off there so that we don't get a characterization of somebody else's pleading. I just wanted to know what document it was that Mr. Keller was referring to earlier
Sure.
as that post-hearing brief. Mr. Keller, did you help write those public comments in that docket? KBCA public comments?
I believe I was part of the process. I know that there were a number of folks that were engaged in that. So I don't know if I was the primary drafter. I may have reviewed it at one point, though, yes.
Okay. And were the comments specifically related to anything to do with their proposal? Do you remember what the comments said, or do you, well, let me ask this. Do you remember that the comments were primarily around a request by KBCA to deny the waiver application until the commission promulgated pole attachment regulations?
I'll be honest, Mr. Chairman, I don't remember the specifics of what our comments were in that. Todd may be able to refresh my recollection on it, but I don't remember the specifics. I'm sorry.
Okay. So, let's just, your firsthand knowledge with Charter. Does Charter have any customers in Kenergy's territory that would be defined as unserved or underserved pursuant to 278-5464?
Because our lowest broadband speed that we provide across the Commonwealth is 200 megabits by 10 megabits, then I think the answer would be no. Everywhere that we have service within the Kenergy service footprint, those homes and businesses would have access to that level of service.
And do you know if any KBCA members provide retail broadband service that does not meet the definitions of served, that would be defined as unserved or underserved under 278-5464 in Kenergy's territory?
I am not aware of any that would not provide at least those minimum levels of service.
Are you aware of any KBCA member that intends on providing service to unserved and underserved areas that overlap or correlate with the Kenergy territory?
I'm not familiar with the specifics of each of our association members' build-out plans. I know that many of them are aggressively pursuing different opportunities to expand into unserved areas, including my own company. But I don't know the specifics of that, but I do know that there is there's a tremendous amount of energy and focus on getting broadband to unserved areas, and I know our member companies are certainly part of that.
Yeah, and I want to be clear about my question. I'm not asking about each KBCA member. I'm asking, do you have direct knowledge of whether any KBCA member intends on providing, providing broadband service to customers in Kenergy's territory that are currently defined as unserved or underserved?
I know that there will be at least one company that will be looking to do that, yes, to expand to areas that do not have broadband, yes.
All right. So you were discussing a challenge process earlier, I think in relation to the bill that sets out the broadband fund that is located at the Kentucky Infrastructure Authority. Is that correct?
That's correct.
Okay. When was that, when did that bill go into effect? Well, let me ask, don't want to ask about when it went into effect. In what year was that bill passed by the General Assembly?
2020.
2020. And was that challenge process part of the bill that passed in 2020?
It was outlined in the legislation, and then the regulations that were established by the Kentucky Infrastructure Authority went into effect. They actually did not go into effect until this past summer. I'm not sure the specific date of that, but that followed after the General Assembly appropriated funds. So the legislation that established the fund passed in 2020, but it was not funded at that time. It was funded subsequently in the 2021 session.
And KRS 278-5464 that came out of House Bill 320 includes the identical language or very similar language for those definitions of broadband, unserved, and underserved. Is that your understanding?
I believe they are the identical definitions, yes, in both of those pieces of legislation.
Well, so you were discussing that part of what you were wanting to provide is a little bit of background from your involvement to describe the legislative intent. Do you have any idea why then the legislature didn't include, from any of your discussions, that same challenge process for 278-5464?
I don't know. I don't know why that was not included. We were not we were not opposed to the legislation this past session, and so we were not deeply engaged in the legislative language as it was going around. So I was not part of those conversations about why or why not to include that information.
You weren't opposed to any portion of House Bill 320 or the specific portion here that ends up in 278-5464?
Well, we were not the specific portion related to the electric cooperatives into broadband. We were not opposed to that. There was some later language that was included in that incorporated some regulatory jurisdiction of broadband that I think the entire broadband industry and others were opposed to, but not the language that related to the electric cooperatives.
I was going to be surprised if that wasn't the case. Are you aware of KBCA members bid on any of the RDOF areas that are subject to the current application? Any of the census tracts that were listed in the RDOF that overlap with Kenergy's territory?
I am not aware of any that, or I'm not aware of the bidding that occurred there. I don't believe that that there were any member companies that won RDOF awards within the Kenergy service territory.
Okay, but you have no personal knowledge of whether any KBCA members bid on any of those census tracts that ultimately are subject to the underlying application?
I don't know what the bidding strategy was for any of the association members.
So I just want to make sure that I'm clear. The purpose of the intervention is to effectively turns on the definitions of unserved and underserved, and I guess technically the definition of broadband, and KBCA's alleged interest in ensuring, I guess it's KRS 278-5464-3A, the portion that says that a distribution cooperative may facilitate the operation of an affiliate engaged exclusively in the provision of broadband service to unserved or underserved households and businesses, that you all intend, the purpose of your intervention, just want to make sure I'm clear, is to provide evidence related to whether the leasing of the excess capacity to an affiliate engaged exclusively in the provision of broadband service to unserved or underserved households and businesses, whether or not those proposed households and businesses are unserved or underserved. Is that correct?
Yes, sir. That's correct.
Okay, and just one or two questions on that. you state that the current maps that you would intend on providing to give us evidence on that subject are proprietary or confidential. Do you have any idea whether it's KBCA's position that if granted intervention and provide those maps, that it would maintain, that it would request that those maps continue to be confidential and proprietary?
I believe we would request that they would maintain that status, yes.
So that raises another question in that effectively KBCA, if granted intervention in this matter, would then use that intervention in this case to then leverage intervention in every other case from here on out, in that it has the proprietary maps that are not publicly available for the commission's consideration in subsequent applications, and therefore will have a special interest in all of these cases in perpetuity. Is there any anticipation that the information that you have in these maps will ever become public, that you'll ever have to provide that mapping information to the FCC, to the Kentucky Infrastructure Authority, or to any other, public body to indicate who actually is unserved and underserved?
Yes, and I can't speak to whether or not we would seek intervention in any future cases. I don't know the answer to that, but I do know that the FCC has undertaken a significant effort to update and refine their Form 477 map. So, for example, they are going to be transitioning those maps from a census block standard to a much more granular standard that will denote the network outlines of providers. So that is going to be an effort that we understand. Well, we've actually already provided some information to the FCC in this effort. We expect, based on what we have heard. Now, this is I know that the timeline of this has shifted a bit, but we understand that those maps would be published on an anonymized basis that would incorporate KBCA members and other broadband providers across America. That they would be published likely later in 2022. So the second half of 2022 is what we have heard. Now, obviously, the FCC has discretion to change that, and they very well may, either through pushing that date back or accelerating it, but we're not sure. But we do expect that there will be much more granular maps that will be far more tailored to the actual provision of broadband across Kentucky and across the nation in 2022.
Is it KBCA's position that nobody in Kentucky that's not a KBCA member can determine which households are unserved and underserved without the KBCA maps and information?
I think as the largest broadband providers in the state, I think we are uniquely positioned to provide a significant wealth of information on where broadband is and where it is not. There may be others that are also providing broadband in certain areas that would also be able to provide information that would be helpful, but as some of the largest broadband providers in the state, we think we have the information that is sort of unique to our association and our members that would be helpful to the commission in this case.
Okay, and just finally, how does having these maps create an interest for the company? Like what is the correlation between having these maps and having an interest in the application?
So I think our interest lies in providing the commission with information about where our networks are and where they're not. And if the legislation, if the language in statute suggests that electric cooperatives can provide service in areas that are unserved or underserved, then having that information to understand where service is today would be informative. So I think that's the sort of the crux of where our perspective is on this, and where we think we can be helpful.
And just succinctly, that map will help present issues and develop facts that can assist the commission in adjudicating the underlying matter? Is that?
Yes, that is absolutely our perspective, Mr. Chairman, yes.
Okay. All right, Mr. Osterloh, do you have any redirect?
No, Mr. Chairman, no redirect.
Okay. Mr. Osterloh, would you like to call your other witness this morning?
No, I don't believe so. I think Mr. Keller has covered everything that we need to cover today for this hearing.
Okay. All right. And so is that, at least on this petition motion for intervention, is that the KBCA's case?
Yes, it is.
Okay. Mr. Hopgood, do you intend on presenting your witness this morning?
No, Your Honor, in light of the testimony, we don't feel the need to present any witnesses.
Okay. And I guess for Kenergy and for KBCA, is there anything else, any other issues that either of you would like to have the commission take up this morning?
Not on behalf of the association. I think we've adequately briefed the issues and appreciate the opportunity to elaborate some of the facts that go along with our motion.
Mr. Hopgood?
Nothing further, Mr. Chairman.
All right. We will we'll get an order out shortly. And as always, if there's ever anything, please file a motion or petition.
Thank you, Mr. Chairman.
Hearing nothing else, this hearing is adjourned.
Thank you.
Thank you.
Thank you.